Yes, be ready. Start. Against the said interim order, the Union of India approached this court by way of civil appeal number 4316 of 1991 stop. The appeal was allowed by this court by its order dated September 10, 1992, and the tribunal was directed to deal with the matter in the light of the observations made by this court in Union of India versus A.N. Saxena stop. It was further directed that in the meanwhile the disciplinary proceedings initiated against the respondent on the basis of the memorandum dated February 7, 1991 would continue stop. It is necessary to notice the observations in the said judgment stop. The bench first dealt with the submission that no disciplinary proceedings can be taken against an officer in respect of his judicial or quasi judicial functions stop. It rejected the contention following the decision of this court in Union of India versus A.N. Saxena stop. While rejecting the said contention, the bench drew particular attention to the following observations stop. In the first place, we cannot but confess our astonishment at the impugned order passed by the tribunal. In a case like this, the tribunal, we feel, should have been very careful before granting stay in a disciplinary proceeding at an interlocutory stage stop. The imputations made against the respondent were extremely serious, and the facts alleged, if proved, would have established misconduct and misbehavior stop. It is surprising that without even a counter being filed at an interim stage, the tribunal, without giving any reasons and without apparently considering whether the memorandum of charges deserved to be inquired into or not, granted a stay of disciplinary proceedings as it has done stop. If the disciplinary proceedings in such serious matters are stayed so lightly as the tribunal appears to have done, it would be extremely difficult to bring any wrongdoer to book stop. We have therefore no hesitation in setting aside the impugned order of the tribunal, and we direct that the disciplinary proceedings against the respondent in terms of the charge sheet dated March 13, 1989 shall be proceeded with according to the law stop. In fact, we would suggest that disciplinary proceedings should be processed with as early as possible and with utmost zeal stop. New para. The bench further opined that the present case is fully covered by the aforesaid decision of this court, and considering the facts and circumstances of the present case in the light of the said decision, the impugned order passed by the tribunal cannot be upheld.